Hello, I trust that everyone is well. I welcome you to Kabale University Faculty of Law. My name is Dr. Charlotte Kabaseke, a lecturer and currently the acting dean of the Faculty of Law of Kabale University. I will be taking you through Introduction to Law, a course whose major aim is to introduce you to the basic aspects of law before you interact with other areas of law or courses which you will be studying at this faculty. In this course, we are going to look at the definition of law. We shall define law. We shall highlight the characteristics of law from the definition that we shall have arrived at. We shall also talk about the purpose of law, the classification of law, or different categories of law. We shall then look at the sources of law, which is basically aimed to introduce you to where Uganda derives its law from, or where did we get our law from as Uganda. I'll then introduce you to the lawmaking process on how laws are made in Uganda. And as you might be aware, we have three arms of government: the executive, the legislature, and the judiciary. And although it is the role of the legislature to make law in Uganda, it is the role of the judiciary to implement that law. So it will also be important for you to be taken through the court process or the court system in Uganda, so that you get a glimpse of how judges in the courts of law really arrive at decision making and interpreting the law in order to arrive at the right decisions or fair decisions while adjudicating cases. And because as part of your duties and at the law school, and also because most of your time will be revolved around reading cases as part of the law in Uganda, you'll be introduced to writing a case note or reading judgments, court judgments, and interpreting the same. And you'll basically be taken through the techniques of writing a judgment, because as you know, some of you will be judicial officers in future. And then because you're going to take your first exams in law school, we shall have a discussion later, and you'll be given tips and guidance on how to write and pass the law exam. So in summary, that's what the content of Introduction to Law is. According to nature is what is law, according to them. We then look at John Austin, Jeremy Bentham, Thomas Hobbes, among others, who are the proponents of the positivist school of law. And the positivist school of law, or the positivists, really argue that law are those commands that are given by a sovereign, that whoever is in power and whatever they dictate is what should be law. Whether the people who are being governed agree with it or not, that is what becomes law. There's no room for negotiation. So according to them, whoever is in power, whoever the command is, whoever the sovereign is, will dictate or will say what the law is, and that's what will become law at that time. The pure theory of law, as advanced by Hans Kelsen, on the other hand, argues that law cannot be law except if there's a constitution in place. The positivists introduced the concept of the grand norm and argue that there may be so many other guidelines and laws maybe, but there should be a constitution which sets the standard of behavior for everyone in the community, which sets the standard of conduct for everyone in the community. And therefore, they believe that there may be so many other laws, but they are not really law unless a constitution is in place and has dictated the order of things. Of course, you realize that the system in Uganda really is biased towards the Hans Kelsen pure theory of law, as is commonly known, because we have a constitution in place. There are many other scholars, including the Marxists, as advanced by Karl Marx, who basically argue that good law or law is really based on what favors the economy, what supports the economy at that time. And they argue that in future, communism will take over most of the countries and governance, and of course that at the end of the day, what the sovereign guides in respect to the same is what will be known as law. And then of course we have the realist movement. The realists believe that law is really the reality that is on ground, that whatever is reality, whatever is happening on ground in a particular community should inform what the law is. That law shouldn't be based on ideas of probably what might happen in the future or what is anticipated, but rather what is real on ground, so that the reality on ground, the circumstances on ground, should really inform and dictate what the law is. Then we have the historical school of thought as advanced by von Savigny. We have the sociological school of thought as advanced by Montesquieu and Roscoe Pound, among others. And these two schools are similar, with the sociological school basically advancing the fact that we cannot define law if it is not in reference to our customs, that our customs inform law, that all of us belong to communities, and those communities have customs and beliefs which shape the standard of behavior in those different communities, and that we can't say that we have law if it does not speak to the customs of each community. And then the historical school similarly advances culture and say that before we can say that we have law, it should speak to the culture of the specific community to which it applies. So we'll quickly then go to the next step, which is what then is law. Having seen that, what then is the purpose of law? The purpose of law is basically it's used as a tool for social control, and in most cases to prevent errant behavior or to control errant behavior. It guarantees civil rights and liberties. Every individual has rights, and in Uganda they are guaranteed under Chapter 4 of the Constitution of the Republic of Uganda. So law is in place to ensure that citizens enjoy those rights. It ensures public safety. For example, we have traffic laws like the Traffic and Road Safety Act. Law ensures public health, among others. We have the Public Health Act. The law helps protect people's property. The law protects the environment. The law is used as a tool for fiscal policy and regulates the economy. That's why we have tax laws. Law fosters cooperation and good neighborliness between individuals, because you have to be at peace to live at peace with your neighbors. You can't, violate your neighbors' rights and walk away scot-free. So in a way, this forces people to live in harmony with each other. And of course, the law also helps governments or countries or states to be accountable to their citizens, in the sense that states are under obligation, for example, to protect their citizens and their property. So when we look at branches of law like criminal law, administrative law, constitutional law, among others, it is just an indicator that law is in place to also hold governments accountable to their citizens.